Steve Brown's my name. I'm from Etienne Lawyers, and we're going to be discussing the uses and abuses of statutory demands. A statutory demand is a creature of legislation. It derives from section 459 E of the Corporations Act. As it derives from the Corporations Act, it is a specific procedure whereby creditors can seek immediate or prompt payment of debts that are due and payable by debtor companies. The use, therefore, of statutory demands are those for creditors against corporations, not against individuals or other forms of business associations, unless the other form of business association has some corporate entity involved with it, such as a corporate partnership or a trust. The use of statutory demands must be in strict compliance with the procedures set out in Part 5.4 of the Corporations Act, which commences with section 459 E. You must issue the statutory demand, you must have an affidavit in support, and the statutory minimum amount which can be sought at any time is a debt that is currently due and payable of no less than $2,000, although there are some discussions that this amount may well increase to $3,000 in the near future. The process of using a statutory demand is a simple one. First, one must ascertain that there is a debt that is due and payable and a debt that is not in dispute. Secondly, you prepare the statutory demand with an affidavit in support, and the law requires the creditor to serve the original statutory demand and original affidavit in support upon the debtor company. The proposition for that is Vic Work Cover Authority and K's Proprietary Limited, 2001, 39 Australian Company Security Reports 281. The form of statutory demand is set out in the Corporation's rules, and it is Form 509 H, as required by section 459 E, subsection 2, paragraph e. It is necessary that this particular prescribed form be used. The form must be in writing. The form is to be used for a single debt or a number of debts against the same debtor company. The demand must be signed for and on behalf of the creditor, and there will be some discussion later on as to who has the requisite authority to sign statutory demands. The affidavit in support that must accompany the 509H form is a document that verifies that a debt is due and payable by the debtor company, and it is not mandatory but certainly advisable, in my opinion, that the basis upon which the debt arose is stated and clearly evidenced by the affidavit in support. Like with the statutory demand itself, the form of affidavit is a prescribed form. The purpose of the statutory demand is to be a formal affirmation of there being a debt that is due and payable, not to demonstrate or to categorically prove that a debt is indeed due and payable. So you don't need to go to the same degree of evidentiary exposure that one would do when putting an affidavit for an originating process in the District Court or the Supreme Court. The question of who can swear an affidavit in support has recently come to the attention in Fargi Australia Construction Proprietary Limited and AC Professional Accounting Proprietary Limited. 2009 New South Wales Supreme Court's